Good to go, sir.
Yeah. Good evening to all of you. We today discuss about Order 21, Rule 58. It is popularly called claim petition. This claim petition is filed under Order 21, Rule 58. That is where an attachment of property has been ordered, be it movable property or immovable property. Then in that case, the judgment debtor is not entitled to that property, but that property is attached. Then in that case, a person who has got right, title and interest over that immovable property or movable property can file a petition under Order 21, Rule 58, and it is popularly called a claim petition. Here, where attachment is questioned, then that the property is not liable for attachment, it can be adjudicated. For example, if you look into Section 60 of the Civil Procedure Code, it says what are the properties that cannot be attached. For example, salary up to 1,000 and above 1,000, 2/3 is not liable for attachment, and only what is attached or liable to be attached is only 1/3. Or let us say the attachment has been sought or obtained on frivolous grounds. Then in that case, a claim petition can be filed not necessarily by the judgment, not necessarily by the defendant, but it can also be filed by the third party who has got rights over the property, movable or immovable property. Then once a claim petition is filed, it has to be filed in the form of a verified petition under Order 21, Rule 58. Please remember, most of us, what we do is when we file an interlocutory application or a claim petition, we file it with a petition and affidavit. Here, as far as claim petition is concerned, the cardinal rule is that a claim petition has to be filed like a plain, and the necessary documents which supports your claim petition or the grounds on which you want the attachment to be raised has to be clearly and succinctly mentioned. There shall not be any vague allegations or averments made in the claim petition. And the consequences of filing a claim petition is an attachment has already been effected, but that attachment is sought to be attacked or challenged on various grounds. What are the various grounds? It depends on facts and circumstances of each case. And normally, claim petition against attachment is filed under Order 21, Rule 58. Order 21, Rule 58 states it should be filed in the form of an EA or execution application if the matter is in execution. But if it is in the suit, an IA can be filed by way of a claim petition, and normally it is filed only in execution petitions. A claim petition is filed where the attachment is challenged. Then in that particular case, once the claim petition is filed, then the other side will be given an opportunity of filing the counter and the necessary documents. Then in that particular case, what happens is a claim petition is heard, a regular inquiry is conducted as if it is an original suit, as if it is a separate claim. And once a claim petition is heard, the court has got the discretion either to allow the claim petition or to disallow the claim petition. Then the question is, what is the scope of inquiry in a claim petition? Whatever inquiry can take place in a suit before the decree or after the decree if the property is attached, and the vice or the legality of the attachment can be questioned under Order 21, Rule 58. Please bear it in mind, what is filed in a claim petition is in the form of a verified petition under Order 21, Rule 58. Then along with the claim petition, you are also supposed to file the necessary documents substantiating your claim against the attachment. And once the claim petition is filed, notice goes to the opposite side, and the opposite side will be given an opportunity of filing a counter to your claim petition. And once the counter is filed, the court determines the questions that has to be determined in the claim petition against the attachment. Suppose the court, after inquiry, comes to the conclusion that the attachment has been obtained by fraud or by irregularity or illegality, then the claim petition is allowed, and for all practical purposes, the attachment will be vacated or attachment will be raised, rather put it in a correct form. Then you got the leading case on this aspect is 2002 6 ALT 3.2 bracket DN OHC. There is notes on recent cases. Here, leading case is 2002. Again, I repeat, 2002. Yes. The leading case on this aspect is 2002 6 ALT 3.2 bracket DN OHC. Here it is provided that appeal can be filed against orders and execution applications. Here, affidavit that is the appellant was the DHR and the respondent's property was attached as no security furnished. Claim petition was filed. No period of limitation cannot be thrown out on the ground of delay. The executive court has to decide. Here, please remember the law of limitation does not apply as far as claim petitions are concerned. This is a fundamental principle you have to note. This particular judgment, the decree holder filed the appeal before the appellate court and questioned the dismissal or the question the allowing of the execution petition. Then, or it can be the claimant also, the claim petitioner also can file an appeal against an order passed in a claim petition. Then the question of limitation was raised, saying that the petition application was not filed within time. The court in this particular case said, nowhere in the articles of the Limitation Act period is mentioned for filing a claim petition against an attachment. So, a claim petition can be filed at any time. The question of delay or otherwise does not arise as far as appeals against claim petitions are concerned. But once a claim petition is filed, it is a duty of the court where the claim petition is filed to adjudicate upon the matter and give a proper finding. And in case a proper finding is not given, there is a misappreciation of facts, then in that case an appeal can be filed. The question of delay has no consideration as far as an appeal against execution application is concerned. This is the leading case reported in 2002 6 ALT 3.2 bracket DN OHC. That means short notes. 2002 6 ALT 3.2 DH bracket DN OHC. That means notes on recent cases. That's a very short note which is given. That means the ratio of this judgment is that appeals can be filed against orders in execution applications and the respondent's property was attached as no security was furnished. Claim petition was filed. No period of limitation cannot be thrown out on the ground of delay. Executing court has no other option than to decide the matter irrespective of the delay in filing the execution. Again, I repeat the ratio of this case. A claim petition was dismissed and the claim petition was allowed, rather I put it that way, and the decree holder filed an appeal before the appellate court and raised a ground saying that it is barred by limitation. The claim petition ought to have been dismissed. But the appellate court in this case said what they said was and under the Limitation Act, there is no section or article which prescribes the limit or the time limit for filing an execution application as and when an EA or a claim petition is filed against attachment. The court has to adjudicate upon it and give its findings. The court cannot abdicate its duty and say it is time barred. So, as far as delay is concerned, it's not a ground for disallowing a claim petition. The court has to go into it, merits of it, look into the facts, look into the documents, and give a finding as to whether the claim petition is maintainable or not. Court cannot summarily throw out the execution application on the ground saying that it's filed after an enormous delay. So please remember the ratio of this case is delay is not the criteria for throwing out a claim petition. That is that's the leading case reported in 2002 6 ALT 3.2 bracket DN OHC. Then we have the Rule 59, which speaks about once a claim petition is filed, it does not end with that. You can always ask for stay of further proceedings under Rule 59, saying that pending disposal of the claim petition, all further proceedings in the case has to be stopped in execution, and the stay petition should be heard, and then alone it can be proceeded against. That is Rule 59.
Sir, Tara Hostel.
Here,
This is organization. ఏదైతే ఈ పర్టికులర్ సెక్షన్ సెక్షన్ 21 there are a lot of things కొంచెం స్లో పేస్ లో people should understand.
Sir, what are the contents you mentioned in a
Slow pace లో
What are the contents you mentioned in a claim petition? First and foremost is the claim petitioner has to urge, saying that he has got an interest in the property which is sought to be attached. And the property does not belong to the JDR or the judgment debtor, it belongs to him. And he says, I acquired this property through some other mode, and the necessary document has to be filed into the court and say, and the claim petitioner has to say, wrongly this property has been attached, please raise the attachment. And the claim petitioner, when he comes to the court, he has to allege and prove and establish that he has got an interest in the property which is attached. It does not belong to the judgment debtor, and the DHR or the decree holder cannot proceed against that property for various reasons. Then in that case, the executing court or where the execution petition is pending has to adjudicate or has to decide the legality or the truth as far as the claim petition is concerned, and must give an opportunity to the claim petitioner to give his evidence. And based on the evidence and cross-examination on either side, the claim petition is disposed of accordingly. I'll just give you another example as to how a claim petition has to be drafted. Suppose, let us say, the decree has been obtained by a particular decree holder against the judgment debtor. Then let us say the judgment debtor has only got a joint interest as far as the property is concerned, or the property belongs to his wife. It does not belong to the husband. Here, a question arises, sir, under Hindu law, once a person gets married, they are husband and wife, and they are termed as Ardhanari. The male is termed as the Ardhanarishwara. But the bane in our country is the wife's property is different and the husband's property is different. The wife can file an application before the court by way of a claim saying that the attachment that has been ordered against her husband is not the property of the husband, but it belongs to her. Then she can file the necessary documents to show that she has purchased the property and that the property stands in her name. Her husband has nothing to do with the property and it has been wrongly attached. Then in that particular case, when the wife files the claim petition, she has to allege, prove and establish that she is the owner of the property and her husband has no share in the property. Husband is not the owner of the property and the attachment is wrong or illegal. Then in that particular case, facts have to be mentioned and the necessary documents have to be filed, and then the court has to adjudicate upon it on the evidence recorded. Here, I'll give you one more instance, sir. Here, what happened was, in our own cases, what happened was a particular person was a judgment debtor, chronic judgment debtor. Then he was driving an ambassador, that is Mark IV. In those days, Ambassador Mark IV was a luxury car. Whoever was owning an Ambassador Mark IV, especially black color, was supposed to be an aristocrat. Then what happened was the decree holder kept a watch over the movements of the judgment debtor and said, sir, my good days have arrived. I have noted down the number of the car and the make of the car, and also but the judgment debtor was driving that car. Then what happened was an attachment was sought to be taken against the car driven by the judgment debtor. Then the wife of the judgment debtor filed a claim petition before the court. Sir, it does not belong to my husband, it belongs to me. And she filed the RC and other necessary documents to prove and substantiate her claim. Then the court, in a humorous way, remarked, what a lucky person this man is. He's driving at both ends. He's driving his wife at home and driving the motor car. And the wife came with a document called Naukar Nama. She said, I've appointed my husband as a driver. He is only my driver. I'm only paying him a salary of 500 rupees per month for the services rendered. Then the courts came to the conclusion that the car does not belong to the husband, but it belongs to the wife. And the wife's car cannot be attached in execution for the debts due and payable by the decree holder, and the claim petition was allowed. I'll give you one more instance in Hyderabad. There is a particular tent house called Hanuman Tent House. There's an old man aged about 85 or 88 years sitting in the counter. He does not have legs. He has to be lifted bodily and made to sit in the counter. Then he was a person indebted to many people. One of the decree holders brought an action against the property owned and possessed, said to be owned and possessed by that person who's sitting in the counter. Then the grandson of the old man came forward and said, Sir, after all, my grandfather is only my naukar. I'm paying him a salary of 1,000 rupees, and the tent house does not belong to him. I got the trade license. I got everything as far as the shop is concerned. He is only the manager of the shop. Then the court in this particular case said, you cannot proceed against the movable property of some other person. Though a person sits in the counter, transacts the business, he cannot be liable for the debt, and the third person's property cannot be attached in execution. So these are the various means to avoid the payment of the debt to the decree holder, the payment of debts to the decree holder. So a decree holder, at the time he lends the money, he has to be very, very careful, more particularly when it is secured by a collateral security by deposit of documents. He has to inspect the documents whether the property really belongs to the judgment debtor or not, or belongs to some other third person. Suppose rightly or wrongly you attach that property and the property belongs to some third party, the third party can always file a claim petition under Order 21 Rule 58 questioning the attachment. Though he is not a party to the proceedings, for the purpose of the execution petition, he becomes a party because he files an execution application. Again, I repeat that the execution application which is filed should be in the form of a verified affidavit. It should not be in the form of a petition and affidavit, and it is normally filed under Order 21, Rule 58 CPC. And during the pendency of an execution application, you can also ask for stay of proceeding against the property pending disposal of the execution application, that is the claim petition. And normally Rule 59 says stay can be granted till the disposal of the claim petition. And the judgment which I cited earlier says delay is not the criteria as far as filing claim petitions is concerned. The question, executing court, whenever an application is filed by way of a claim petition under Rule 58, court has no other option than to adjudicate upon it and then give its finding whether the claim petition is maintainable or not maintainable. Court cannot abdicate its duty and say delay is there, so I'm not going to hear it, I'm not going to dispose it of. But in that case, in that particular case which I cited, law of limitation does not apply as far as claim petition is concerned. Then I'll give you one more instance. Suppose, let us say, the property is already hypothecated to any bank or a financial institution, and the bank has issued notice to both the husband and wife, because the wife also is a co-obligant as far as the loan transaction is concerned, and the property stands in her name, and the collateral security which has been offered is a property which belongs to the wife. And the wife also pays the money from time to time as far as the debt is concerned, and she has been recognized not as a debtor but as a guarantor. Then in that particular case, the court came to the conclusion that the property does not belong to the JDR. He has no saleable interest as far as the property is concerned. The property actually belongs to the co-obligant, that is his wife, and the property cannot be attached. And attachment, even if ordered, can be raised in that claim petition. So these are the disastrous consequences as far as Order 21, Rule 58 is concerned. In this case, I also cite Section 95 of the Civil Procedure Code, which says that in case you take a wrongful attachment, in case to harass the opposite side, you take an attachment order, the other side is entitled for compensation for wrongful attachment for the mental pain and anguish which is caused to him because of the attachment. That is Section 95. Then, here, as far as the other rules are concerned, 60, 61, 62, and 63, they have been repealed. You don't have those rules as on today. So, next one is Rule 64. Rule 64 says if a property has already been attached, and then the next step is the decree holder can apply to the court to sell the property which has been attached. If the decretal amount has not been paid in spite of the attachment, the decree holder can apply to the court, sir, please sell the property which has been attached. Then the court has got the power to order for sale of the property which has been attached, be it movable property or be it immovable property. In that case, what is the contingency, sir? The following rules will substantiate that. That is the movable property which is attached, even after attachment, the money has not been paid, then the movable property will be brought to the court and by public auction, by the bailiff, it will be sold, and the sale proceeds which is received or is recovered from out of the sale will be credited to the credit of the suit, and the decree holder has got the right of claiming that amount or withdrawing that particular amount. Then the question arises, who conducts the sale? Normally, here in Hyderabad, the sale is conducted under the aegis or supervision of Musa and Company, which is a leading auctioneer and recognized by various courts also. But the bailiff of the court conducts the auction. And when the auction is conducted, I'm only dealing with movable property. When the auction is conducted, the value of each article will be mentioned by the decree holder. It shall not be sold for an amount which is lesser than the amount which has been mentioned in the execution petition. Then the purchaser, whoever wants to bid in the auction, the procedure is 25% of the money he has to deposit before the bailiff. Please remember, you just cannot go for fun sake and bid in the auction. First and foremost is like EMI, you have to deposit 25% of the amount with the bailiff and then take a receipt. Then you will be given a permission to bid in the auction. Then the auctioneer who auctions the property will have to go to the highest amount and see whether the property can fetch more than what has already been bid. But please remember, it is mostly forward in breach rather than observance. Because when movable property is sold, there is a syndicate that is formed. That is, people from a particular area alone bid in the auction. Others are prohibited or others are prevented from participating in the auction. And sometimes what happens is the property is knocked down for a price much lower than the expectations. Because please remember, the movable property which is brought to the court will be auctioned by the bailiff and then Okodosari, Rendosari, Mudosari, that's what we call it. And when the highest bid is received, then he knocks down the auction, knocks down in favor of the person who is a successful bidder. And please remember, this sale which takes place is also subject to confirmation by the court. It should not be undersold, or it can fetch more money, but the auctioneer in collusion with the syndicate tries to sell it at a lower price than what the property would fetch. Then in that case, court will not confirm the auction, but court will direct re-auction of the property. And once re-auction is ordered and it realizes lesser than the amount which is mentioned in the EP, then from the purchaser who purchases the property, that money will be recovered. Then the most important thing in this procedure is proclamation of sale. The word proclamation comes from the word proclaim. Proclaim means announce, or by announce with wide publicity. Here, normally proclamation is made in the language of the court. Normally, it depends from state to state what is the language of the court. As far as Telangana and Andhra is concerned, English and Telugu is followed. So it should be made in the language of the court, and it should be widely publicized, and then notice has to be given to the decree holder and the judgment debtor, and property which is sought to be sold has to be clearly mentioned in the proclamation. And the time and place where the property is going to be auctioned has to be clearly mentioned. And next one is the revenue which the property can fetch, revenue which is paid in respect of that property is also mentioned. And then the takatu, or what is called the encumbrances, which are in respect of that property is also mentioned. And then amount of recovery, whatever is the amount to be recovered, it is called which is claimed by the decree holder is also mentioned, and other particulars which are necessary. Please remember, in a proclamation, they also include a term called upset price. Upset price means the property should be sold only at that particular price, and it shall not be undersold for a price lesser than the amount which has been mentioned in the sale proclamation. Why? Because the interest of the judgment debtor also is involved, and the interest of the decree holder also is involved. And the question is, cannot be undersold, and then it shall be sold more than the upset price, but not lesser than the upset price. Suppose the last bid which is received by the auctioneer is less than the upset price, he submits a report to the court, and the court re-auctions the property to see that a higher price is received as far as the property is concerned. One important thing you must remember is, when you mention the encumbrances, who are the other creditors of the judgment debtor also has to be clearly mentioned. And the schedule of property which is offered to be sold will also have to be clearly mentioned. And the time and place where the auction is to be conducted has to be clearly mentioned. And here, a wide publicity is given, normally by publication in two newspapers, new newspapers which are national newspapers, and then wide publicity is given, and public are given the liberty to participate in the auction. And once they participate in the auction, whatever upset price is fixed, 25% of the upset price has to be deposited by the persons who want to participate as far as the auction is concerned. And once the 25% is deposited, the bailiff of the court starts the auction. And once he starts the auction, he tries to come with a lower figure and then come to the higher figure. Whoever quotes the higher figure, the bid will be knocked down in favor of the person who gives the highest bid. And then please remember, the bailiff has no what is called discretion in accepting it. What the bailiff has to do is he has to note down for what figure the property has been knocked down, what is the amount realized from the purchaser, what is the price, how many bidders were there, what were the bids which were given, and what was the highest bid that was given. It is subject to the confirmation of the court. Unless the court confirms the auction and says it is fair and transparent, then in that case the court confirms the auction. And once a successful purchaser is there, court does not execute a sale deed. Court executes what is called a sale certificate. Please underline this word, sale certificate. That means the presiding officer of that particular court where the execution petition is pending, he certifies that A son of so-and-so, age so-and-so, occupation so-and-so, is a successful bidder in the auction held on so-and-so date in respect of the property mentioned in the schedule, and he is hereby declared as the owner of the property, having purchased the property in an auction sale conducted by the court in the above proceeding. And once a sale certificate is given, it is open to the auction purchaser to go to the registrar office and get that certificate also registered. Please bear one thing in mind, court does not execute a sale deed. Court executes what is called a sale certificate. But again, the sale conducted by the court can also be challenged. That is, sometimes what happens is the sale can also be adjourned when it is more than 30 days. That is, it cannot be an adjourned before it is knocked down. Here, court has also got the power to adjourn the sale when the JDR makes an application. Sir, I'm arranging for private sale of the property, or I'm arranging for funds. I'm prepared to pay the money which is due and payable to the decree holder. Please give me 1 month's time or 2 months' time so that I can pay the debt. Please remember, the courts are not that harsh enough. When the judgment debtor himself comes forward voluntarily to say that he is going to raise funds by selling other properties and then paying the debt, then in that case, a sale can be adjourned to a date not more than 30 days. That is what Rule 69 says. Then 71 is defaulting purchaser liable for loss on resale. Sometimes what happens is a purchaser is given time, not that he should immediately pay the money. He is given 1 month's time or 2 months' time to deposit the rest of the money which is due towards the purchase money. Then within that time, he does not make the payment or does not show interest in paying the balance of the amount, then the court orders for resale of the property. Resale of the property is fresh sale of the property. And in case any shortcoming is there, that amount will be recovered from the auction purchaser. That is what is Rule 71. Then please remember one thing is this: you as advocates, should remember under Rule 73, no officer of the court can bid in the auction. No officer doesn't mean that you are the officer, means only the staff of the court, but it's also you as an advocate, because all advocates are deemed to be officers of the court. You cannot bid in the auction. You cannot bid in the auction, and you cannot be a person bidding it. And then if you do it, it is against the Advocates Act. You can be removed from the roles by the Bar Council, and your practice will cease. So no officer of the court shall bid or is permitted to bid in the auction. And in the same way, the decree holder also cannot bid, or the mortgagee, the person who is a creditor, also cannot bid in the auction. It's a specific bar that these people, that the mortgagee means person to whom the property is offered as security, or the decree holder, the person who has obtained a decree, or an advocate, or a person occupying a public office, be it a judge or be it a ministerial officer in the court, cannot bid in the auction. He cannot participate in the auction, and he is barred from bidding in the auction or participating in the auction. And in most of the sales, what takes place is the advocates concerned or the officer of the court nominates someone as his proxy, and the proxy bids in the name of the officer. But though he bids, the officer cannot bid directly. Then here we go to sale of, that is next is Rule 74. It talks about sale of agricultural produce. As far as agricultural produce are concerned, it depends on two contingencies. When the seeds are sown and it's ready for harvest, till such time the crops are raised and the crops are ready to be cut and severed, you cannot attach that property. Once the crops are ready for harvest, it can be severed and then kept in safe custody for preservation. And after it is kept for self-preservation, the court can sell the produce, not otherwise. If the crops are still lying, still liable for harvest, then in that case an agricultural produce cannot be attached. Till such time it is cut and taken to a threshold and then ready for being sold in the market, and then alone it can be attached, not otherwise. Then, so the attachment cannot be ordered till such time the crop is severed and taken for sale. Only in those circumstances an agricultural produce or a crop can be attached. Then 76 speaks about negotiable instruments and shares in corporations through broker. Normally we know in the share market, you got the primary market as well as the secondary market, and none of us go directly to purchase shares. We go through a share broker or a stock broker, as you may call it. Here in this case, the negotiable instruments and shares in corporation through broker, that can also be attached and proceeded against. But negotiable instruments also can be attached under Rule 76. Then suppose movable property is there. It is not sold at once. Lots are made and it's sold by lots. Then here it is said that shall be paid, that is, each lot of marketable movable property shall be paid. Then such sale becomes absolute. So suppose 10 lots are there, different lots. I'm not saying for a moment one lot is there. You have got refrigerators, you have got computers, you have got furniture, you have got ceiling fans, then you have got various items. Then it is not sold at once, it is sold in lots. Then in that case, for each lot, it has to be sold at the highest price and then subject to confirmation by the court, then alone a sale shall become absolute. That is Rule 77. Then we come to Rule 78, which speaks about irregularity or irregularity of any person injured may sue but does not vitiate sale. What do you mean by irregularity? Irregularity means when the proclamation is drawn up, the place is not mentioned, time is not mentioned, name of the court is not mentioned, upset price is not mentioned, the price of each item which is offered for sale is not mentioned, and so on and so forth. Then in that case, no doubt you can question the irregularity, but irregularity by itself does not enable you to question the auction which has already taken place. That is what is said is Rule 78. Then how delivery of movable property or debts and shares are recovered. As far as shares, movable property, or let us say debts are concerned, or shares are concerned, it is by seizure, seizing it from the custody of the judgment debtor and handing it over to the decree holder in execution. Then, if the transfer of negotiable instruments and shares take place, the judge himself can execute a certificate saying that it has been transferred, and then under his name and seal and signature, he can say that the property has been handed over to the decree holder in execution. Then I think we need to.
ఎన్ని ఇప్పటిదాకా ఇప్పటిదాకా ఎన్ని 10 10 12 10 12 కదా మీరు ఏంటంటే ఎలాబరేట్ చేయండి కానీ
I already elaborated.
దానికైనా ఎలాబరేట్ చేయండి అనదర్ 3 ఆ 3 చేస్తాం
85 hours చేస్తే స్టోర్ చేస్తాం. Here, Rule 81 is not that important because vesting order in case of other property in the purchaser. Whoever has purchased the property has been handed over to him. That is called vesting order. Under Rule 81, the court can order the property which is purchased to be handed over to the successful purchaser. Absolutely, these are all small provisions which you need not bother about it. Then here 82 speaks about civil courts, that is small causes courts. Please remember, in the Mofussil area, we don't have small cause courts. Any claim below 2,000 rupees, they are entertained by small cause courts. Only in the metros, small cause courts are existing, but only a civil court can order for sale of immovable or movable property when the value is 2,000 rupees or more. Then 83 speaks about postponement, that is to enable the judgment debtor to raise money. Suppose let us say sale has already been ordered, but the JDR says, sir, I'm arranging for private sale of my other properties. Please try to give me time, postpone the sale till such time I realize the funds. I'm prepared to pay the money and I don't want my property to be sold in execution. Then in that case, the court can postpone the sale for a reasonable time which is asked for by the judgment debtor. That is Rule 83. Then we go to Rule 84. Deposit by purchaser and resale in default, 25% deposit, property can be resold on default. Suppose let us say you are the successful purchaser, you have already deposited 25% of the sale amount, and the rest of the 75% you have to pay. The court grants you time to deposit that 75% within a particular time span, that is 1 month or 2 months, and you don't deposit that money, then what happens is the court orders for resale of the property, and if any shortfall is there, they recover it from the purchaser. That is what 84 says. Then time for payment. Normally under 85, the court grants you reasonable time to the purchaser to arrange funds and deposit the balance within the time that is granted. Then normally the court also says, in case you don't deposit the money, your advance what you have paid at the time of participation in the bid will be forfeited. I think with this we shall stop. That is, we have finished up to Rule 86. We still have 20 to 23 rules to be completed, but after that, straight away I will go to the sections, the important sections of the CPC, which has got relevance as far as that subject is concerned, and then after that, we go to the civil rules of practice, the important provisions of the civil rules of practice. Any questions, please? The interaction time starts. Sir.
Sir.
Yes.
Sir.
Please go ahead.
At 21 to 58.
Rule?
Article 21 to 58.
Yes. Claim petition.
Claim petition.
Claim petition against attachment. Against attachment.
Attachment.
Yes.
Against the attachment after proclamation of sale.
Not after proclamation, sir. If the property is attached, let us say immediately or later.
Property attached and proclamation also
Issued.
declared.
Yes.
Issued. Then claimant and JD are the joint owners of property.
Right.
Father and son.
Right.
Father executed his share released in 2014, but execution petition in 2000.
Right. So suppose if it is the joint ownership of the father and son, let us say for argument's sake, father is the debtor or the judgment debtor. Then if the execution proceedings are initiated either by attachment or otherwise, only the father's share can be attached. That half share can be attached. The decree holder cannot proceed against the other half share of his son.
Okay, sir. Okay,
Then
sir.
otherwise, I say the question of section 53 of the transfer of property is relevant. That is fraudulent transfers. Suppose
It should be bona fide transfer.
exactly. Suppose anticipating that the property will be proceeded against, the father executes a gift deed in favor of the son during the pendency of the proceedings. It is hit by dispendence and is also hit by fraudulent transfers under 52 and 53 of the Transfer of Property Act, and it can be ignored by the court.
Release can be obtained by DHL, sir.
Pardon?
In this case,
Decree holders' rights will be upheld. That is, the transfer will be set or not. But only to the extent of half share you can proceed.
Oh, okay, sir. Thank you.
Not
Thank
full
you.
share.
Okay, sir.
Right.
Okay, sir. Thank you, sir.
Sir, good evening, sir.
Good evening.
Sir, good evening, sir.
Good evening, Babu.
This Surface Act rules are surpassing these CPC rules, I think, sir.
Which one, sir?
Surface Act rules.
Surfacing.
Yeah.
Surfacing
Because
is a
banks.
surfacing is a special proceeding where the bankers are entitled to first proceed against the debtor in a debt recovery tribunal. The procedure adopted there is, suppose collateral security is given. Now the practice adopted is the advocate the particular designated court is there. The designated court appoints an advocate who goes to the spot, and in the presence of the bank officials and the police, the property is attached and a board is put there saying that property attached under surfacing proceedings in so and so, so and so. And then the matter is reported to the court, and the court notes the attachment and is now done through the modicum of the civil courts. But earlier the proceeding was, before this amendment had come, the bank officer himself has got the powers to go to the spot, attach the property, and then take it in his possession. and intimate the judgment debtor that the property has been attached in surfacey proceedings. But now it has been amended, saying that designated court is there where surfacey proceedings take place, and the designated court appoints an advocate commissioner to go along with the bank officials and the police and attach the property and take possession of the property. I am making myself clear to you, please.
Sir, yes, sir. Somehow these CPC rules for the
No, CPC
EP
rules
is
does not apply as far as surface
flexible.
is concerned. It's a special.
Yeah, flexible
special-
and flexible.
Yes, sir.
Thank you, sir.
Welcome.
Any
Any more questions? Any more questions? Or can we conclude the class?
Sir, I am Vijayalakshmi from Guntur, sir.
Yes, sir, please.
Sir, what is the difference between Rule 69 and 83 of the Rule 83, sir? Postman and adjournment.
What did I explain to you regarding 69 and 83, please?
Adjournment or stoppage of sale.
Yes.
69.
Adjournment is, suppose, let us say the judgment debtor comes to the court and says, sir, please adjourn the matter. I am arranging for private sale of the property. Please give me some time so that I can sell my other property, realize the money and pay it to the degree holder. That is what 69 and 83 says. And adjournment is done when the, let us say, the publication which you make in respect of proclamation, it is not according to law, or you don't pay the charges for publishing it in the official gazette, then in that case, the sale is adjourned. Or the time that is given is too short, where the sale cannot take place. Or let us say the sale proceeds or the bidding which takes place is lesser than the upset price that has been mentioned in the proclamation. Then in that case, the sale will be adjourned to a further date. And stoppage means where the judgment debtor comes forward and pays almost half or three-fourths of the amount, then the sale is stopped and adjourned to a further hearing so that the remaining amount is paid. Yes, next please. Am I clear, madam? Yes?
Yes, sir.
Next.
Yes.
Sridhar Garu, do you have any doubt? Any more questions? Can we conclude the class? Any questions? Please come forward with your questions, or otherwise we conclude the class as of today. Please unmute yourself, Galaxy 3 M30. Sir.
Yes.
Sir, Dharma Legal ఏదైనా గ్రూప్ ఉందా సార్ ఇది?
అవునండి.
We do have a group.
My
గ్రూప్ లో యాడ్ అవ్వాలని మెసేజ్ పెట్టాను సార్, నా నెంబర్ మెసేజ్ చేశాను. ప్లీజ్ నా నెంబర్ రాసుకోండి. ప్లీజ్ చెప్పండి వాట్సాప్. చెప్పండి సార్ నెంబర్. సార్
మీ నంబర్ చెప్పండి.
I am putting in the group. Okay, sir. So that you can send me and I can add you. Group లో పెట్టాను సార్ నేను. Okay. Please check this personal message పంపించండి. I can add you in that. ఇది మీదేనా సార్? 89196440. Absolutely. Okay, sir. Okay. Thank you. Any more questions other than this? In subject wise? Start లో పోతుంది మళ్ళీ. All right. Can we conclude the class today? All right. Thank you very much. Sir.